Disclaimer: the contents of this video are for general informational purposes only and do not constitute legal advice. We analyze cases and provide general tips in accordance with Germany's Foreigners' Law and Residence Act, but we do not assume any liability for the accuracy, completeness, or timeliness of the discussed content. For a binding legal assessment and individual consultation, we strongly recommend consulting a specialist lawyer for immigration law. Today, we are dedicating ourselves to a particularly exciting case. Stay tuned.
Real case.
My name is David and I am German. My fiancé is from Kazakhstan. Currently, I live with my mother in a 55 square meters two-room apartment in Nuremberg. To better settle in after the wedding, planned between January and March 2025, my fiancé and I would like to live here together for a few months and calmly look for a nice, our own apartment. Therefore, my mother and I would like to draft a sublease agreement with a friend who is a lawyer for the office. So far, I have been living here without an official contract and contributing to the costs for electricity, water, and internet. What about my fiancé's marriage visa? Analysis, advice, and tips.
Your concern pertains to an important requirement for the issuance of a family reunification visa, particularly the question of whether the living space is considered sufficient. In the case of a marriage visa, the following legal and practical aspects play a role. Adequate housing. The responsible immigration authority generally requires proof of adequate housing for the applicants. The definition of sufficient is based on the number of people and the local housing regulations. Per person, at least 12 square meters of living space are usually required. For children under 6 years old, often less. For you, your fiancé, and your mother, at least 36 square meters would need to be available in the 55 square meter apartment. Proof of living conditions. Since you are currently living in your mother's apartment without a formal lease, this can be problematic for the authorities. A sublease agreement is therefore a sensible solution to legally secure your living situation. The sublease agreement should clearly stipulate that you act as the main tenant of the apartment and that your fiancé is also allowed to live there. This makes the situation understandable for the authorities. The contract should include the following points. Landlord, your mother is the main tenant. 2. Tenant, you as a subtenant. 3. Rental object, the entire apartment or a specific part of it. 4. Rental period, indefinite or for the period until the planned new apartment search. 5. Rent costs, rent, cold and warm, as well as additional costs, electricity, water, internet. Landlord's consent. Check whether your mother's main landlord, the owner of the apartment, needs to approve the subletting. In many rental agreements, written consent is necessary. The following documents related to housing are relevant for your fiancé's visa. 1. Rental agreement or sublease agreement, indicating that sufficient living space is available. 2. Confirmation from the landlord, which verifies the living space and the number of residents. This is required for registration at the residence registration office after your fiancé's arrival. 3. Floor plan of the apartment showing the layout and size of the living space. Draft the sublease agreement in a timely manner and have a lawyer confirm that the regulations comply with official requirements. Clarify early with the immigration office whether the temporary living situation will be accepted for the visa application. Plan to specifically explain the move to a larger apartment in case the authority asks questions about the long-term living situation.